the Workers' Party, Associate Professor Jamus Lim, and Mr. Leong Wan Wai from the PSP took a different approach. You made serious allegations regarding our public officers, regarding our agencies. I do not know why you have to take this approach, especially after I had explained what happened on Monday. I had clarified the facts on Monday. Why is it necessary for Mr. Leong and for Associate Professor Lim to still want to throw our public officers under the bus? Why is that necessary, sir?
Let me start by stating unequivocally that I have deep respect for the hard work that our civil servants put in, often involving long hours and comparatively lower pay than they could have commanded in the private sector. But I feel that it's nevertheless imperative for me to highlight instances where the system that the civil service operates under, which is, to be clear, overseen by this government, is problematic, because our civil servants can only do the best they can within the constraints that they face from the government of the day. So, once again, to reiterate, I'm critiquing the system, not the civil servants. I do not think it's useful to bring in the civil servants as pawns to a political argument. Now, to further clarify, I did not say that there are no protections for the sale of significant assets like Singtel or DBS, but the additional protections are granted by CIRA. Accepting that we do not wish to list every possible Singapore firm under CIRA, I still have not heard a satisfactory reason as to why the designated entities are limited to only those within the military-industrial complex, whereas our total defense pillars clearly go into financial and digital elements. Let me put this another way. Could I confirm with the Minister that this government will never consider listing assets such as DBS or Singtel under CIRA?
Mr. Deputy Speaker, I would like to start by first requesting Associate Professor Jamus Lim not to put words into my mouth. I did not refer to our public officers as pawns, and I don't think he should too. We have deep respect for our public officers. We know that they work hard, they do their work well, and it wasn't so clear earlier when Associate Professor Lim was making all the criticisms about working in silos and having breakdowns of communications that he was referring to the system. Now, if his concern is about the system, I have also explained on Monday and then earlier what happened and why it was not in the ordinary course of operations for MAS when they are assessing information from a financial institution to share that with another government agency. Now, if Associate Professor Lim considers that as a failure, a systems failure, then I presume maybe he could let me know what his counter-proposal is. Is he then suggesting, and I'm not trying to put words in his mouth, I'm only asking, is he then suggesting that anytime MAS receives information, whether there is a reason or not, we should then share it with all other government agencies? I hope that's not what Professor Lim is proposing. I think that will have an impact on investor confidence, and it will affect our pro-business operating environment. So I've explained what happened with this particular case, and I've also reiterated the chronology of what happened, and I hope Associate Professor Lim can accept that account of what happened and not keep repeating unfounded allegations about the public service officers in our system facing constraints from the government of the day when it comes to sharing of information. I don't think there's any evidence, unless Associate Professor Lim can produce evidence. Otherwise, I would like him to please withdraw that rather serious allegation. With regards to CIRA, I've already explained earlier that this has to do with national security. And I also mentioned in my reply that we will also look at whether there are other acts that cover some of these entities. And if there are, then there's no need to replicate this with SERA. So the two examples that Associate Professor Lim kept raising, DBS and Singtel, I've already explained. There are sectoral regulators. In the case of DBS, it will be MAS. In the case of Singtel, it will be IMDA, that would play the role of the gatekeeper. And if you want to acquire shares in DBS or in Singtel that goes beyond a certain percentage, you do need the regulator's approval before you're allowed to do so. So in a way, that's already covered. Thank you, sir.
Thank you, Deputy Speaker. I have two clarifications. First, I don't seem to recall either of the ministers clarifying the questions raised by Ms. He and Ms. Phua about whether MAS needs this bill. In other words, does MAS not have sufficient power within its current jurisdiction to take into account the public interest in having affordable financial products, and therefore, actually, is this bill really necessary? I don't recall either minister touching on this point. Second is a clarification for Mr. Chee, Minister Chee. Would he at least acknowledge that what Parliament is being asked to do today is to pass this legislation that is targeted at a live transaction, a particular one, to introduce a legislative change that would affect that live transaction? And does he not acknowledge that this sends a very bad signal to the business community about business certainty?
Madam Deputy Speaker, I had actually covered both points in my closing speech earlier, but Ms. Lim may have missed it, so if, with your permission, Madam, can I just read those sections again?
Please proceed.
Thank you. So this is what I said earlier, that the bill does not affect any completed transaction because there's no formal application yet by Allianz to obtain effective control and become a substantial shareholder of income. And therefore, there is no retrospective application of the law. So that is what I have said. There's no formal application yet by Allianz. Second, the point about why MAS doesn't have the powers, I've also explained this, that the existing sections 26 and 27 of the Insurance Act, there isn't an explicit provision under the Insurance Act for MAS to take into account the views of MCCY, which will include questions relating to social mission in assessing a proposed acquisition of an insurer with cooperative links. So we can't rely on the existing provisions without this set of amendments. And because it is a proposal that is under consideration by shareholders, there is urgency. So yes, we don't disagree that there is a deal that is being considered, but it is a fact, sir, that there is no formal application by Allianz to MAS.
Thank you, sir. I have two clarifications for the Minister in charge of MAS and one clarification for the Minister of MCCY. In relation to my clarification for the Minister in charge of MAS, I think the Minister mentioned twice that there was no formal application made by Allianz in relation to this proposed acquisition of the majority share stake in income. So I just wanted to ask some clarification because in the proposed new section 33A of the Act, in subsection 9, it states, and I quoted this in my speech actually, this section applies also to a relevant application received by the authority before the date of commencement of the Insurance Amendment Act 2024 that is still pending as of that date. So if there was, can the Minister clarify whether this refers to to this transaction or another transaction? So that's my first clarification. And then my second clarification relates to the urgency, the points that I made about why the urgency of this bill, that such that, within 3 days this was actually going to be, it needs to be passed, going through second and third reading. So I think the question here is that the Minister mentioned earlier that the reason why we are rushing through this bill under a certificate of urgency is because this deal is under active consideration by shareholders. But from my understanding of this, Shareholders can vote however they want, they can consider however they want, but honestly, the offer is ultimately subject to regulatory approval, and that's why it's called a preconditional offer on the offer document. So I'm just wondering, given that, also mentioned in my speech, given that the long stop date is 9 months from the date of announcement, why is there this rush to do this? So that's my second clarification. And my clarification for the Minister for MCCY is, I think I heard the Minister say earlier, this is in relation to the exemption granted to the 2023 Gazetted exemption order. I believe the Minister mentioned that there's some flexibility needed for I guess, to allow to use the surplus to achieve the mission. And I just wanted the Minister to clarify that no conditions were imposed on the use of the surplus in that respect. Thank you.
I had answered Ms. Her's question, and when I used the word flexible, it was in the context of my answer to Mr. Chua's query about the extent to which social mission might evolve. And that was when I used the word flexible. But in the context of the exemption, there was a series of discussions. I mentioned in my speech on Monday that we engaged with Income over a period of time. We exchanged views. They sent various letters representing their position, and it was on this basis that the corporatization and the exemption was granted.
Mr. Deputy Speaker, I'd like to confirm that there's no formal application from Allianz to MAS. The provision that Ms. Her mentioned, that is inserted more for avoidance of doubt. The second point that Ms. Her raised, this bill is urgent. We need a certificate of urgency because the due is under consideration by shareholders. So by having a long period between the first reading and the second reading before the law, the amended law takes effect, actually we give rise to more uncertainty in the market and for the parties concerned. And that's why we are putting forth this bill for Parliament's consideration and for approval.
I'm still a bit confused because, in this kind of condition, as I mentioned earlier, the deal is a preconditional offer. So it's always subject to regulatory approval. So again, the shareholders can consider that. And again, we've got a 9-month long stop date. So I don't really understand why the Minister is saying that, given that it's under consideration by the shareholders, we have to rush through, because shareholders know that regulatory approvals take a certain amount of time, and they know that all these are actually being debated, and then the amendments are being proposed. So I'm not entirely sure that the two are necessarily connected. Thank you.
Mr. Deputy Speaker, I have already explained the reasons from the government's point of view. I accept that Ms. Her may have a different view, but I've explained why we want to provide greater certainty on the decision and on the changes to the legislation for the different stakeholders, including the shareholders, but also other parties who are involved in this deal. That's the reason why we are doing it with a certificate of urgency, but it is, of course, subject to Parliament's approval.
Thank you, Deputy Speaker, for your indulgence. I don't plan to prolong this, but Minister Chee had requested that I withdraw an allegation, if I'm correct, that there was a communication breakdown between different arms of the civil service. I'm happy to make this withdrawal, but I'm a little puzzled because it is actually, in his words, that there was an information gap. This was presented on Monday between MAS and MCCY. Now, I understand I characterized this as a communication breakdown instead, but perhaps Minister Chee is triggered by the word breakdown. Let me, again, I'm happy to withdraw the statement if he thinks it's a matter of terminology. Now, the second point is that he had asked me to make a suggestion, and I did so in my speech, for how I think we should go forward. So this is the constructive part, and that is that I think future transactions of such strategic importance should at the outset involve the establishment of a multi-ministry task force.
Thank you, Mr. Deputy Speaker. I also do not want to prolong this debate, but just to clarify, I wasn't asking Associate Professor Lim to withdraw his comment about the communication breakdown. He's entitled to use that phrase if he prefers to. I was referring to his comment that the public officers are unable to share information due to constraints imposed by the government of the day. That was what I would like to request, that Associate Professor Lim withdraw that comment because that is not true. We do not put barriers to prevent our public service officers to share information. In fact, in this case, the decision to share information was proposed by the public officers and supported by the political office holders on the MES board.